You're watching Inside Automotive with Jim Fitzpatrick.
Good morning, everyone. Thanks so much for joining us here at CBT News. CDK Global is set to pay $100 million to settle a class action antitrust lawsuit. The lawsuit, filed in 2017, was originally against CDK and Reynolds. Reynolds, I should say. However, Reynolds previously settled. Here now with more on this win for dealers is Len Bellavia, founding partner of the law firm of Bellavia Blatt, also known as dealerlaw.com. Len, first of all, congratulations on this big win. And wow, what a huge advantage here you've given dealers.
Well, thank you, Jim. Thank you for having me, and thank you for the congratulations. It only took 7 years, so we've been in the foxhole for quite a long time, and the trial was set for a month from now. So
sure.
Most cases will settle. If they're going to settle, they'll settle right before trial, and
sure,
this one was no different. So yeah.
So to kind of set the table for our viewers, what was the class action suit all about, and how many dealers are part of it?
Sure. So just to give you some background, I'd say about 8 to 10 years ago, I started getting calls from dealers complaining about the prices they're paying for DMS services, and that it got somewhat compounded when dealers, would do business with, let's say, a dozen vendors, some relating to payroll, service, CRM,
sure,
all the different tasks that dealers have to contend with. And what happens is all of the data gets aggregated, and obviously all of the data is with the DMS provider. So it's, in this case, CDK and Reynolds has about 80 to 90%, depending on what market share data you look at, of the market. So they pretty much control that. And what happens is the dealer's own data is not available to them in easy form. So they rely on third-party integrators to develop the information and put it in usable form and then deliver it to the vendors. So at least what we discovered or we felt was happening was CDK and Reynolds got together and colluded and said, well, we're going to charge these third-party aggregators a fee to access the dealer's own data. So it could be $300, $400, and then those third parties would pass that cost along to dealers. So if a dealer had 10 or 15 vendors, multiply that times these aggregation costs, these processing costs,
right,
and they would be passed on. So month after month, year after year, dealers were paying what we claimed were artificially inflated prices that were falsely engineered by these two defendants because they had 80 to 90% market share. So when you have what's called duopoly power, you must deal in a competitive fashion. And our claims were that they were dealing in a non-competitive fashion, taking advantage of their duopoly power and overcharging dealers. And the interesting thing about it is that the money at stake is large for each dealer per rooftop, but it's not always practical to bring a lawsuit against a key vendor for obvious, they control your destiny, so it's not politically popular to do.
Right.
And it might not pencil out because if you're being overcharged $100,000, you don't want to spend $200,000 in legal fees to recover that.
Sure.
So, and not only CDK and Reynolds, but all of the class action cases you hear about in the marketplace, oftentimes involves minor overcharges that many companies get away with because they know it's not practical for the victim.
Yeah, it kind of flies under the radar, right?
That's right.
Yeah.
So when you get enough people together to say, enough is enough, which is what happened here. So I said, all right, dealers, there seems to be a groundswell because I'm getting calls over and over again. So we did a little research, discovered that, CDK and Reynolds, at least in our view, were conspiring to overcharge dealers. So what I did is I'm a dealership attorney. I'm not a class action attorney. So there are firms out there that only do class actions.
Sure.
I vetted, what I consider to be the best firms in the country. I brought in Milberg, which is a New York City firm. In my view, they're the best class action firm in the country. Peggy Wedgeworth is the partner who handles these class actions. So she was my partner, so to speak, in prosecuting this case. So she did the class action litigation. I did the dealer data part of this and getting the clients together. So we orchestrated it, started it about 8 years ago. went through the channels, and here it is a month before trial. We were able to negotiate a settlement with CDK. I will tell you that Reynolds settled several years ago,
Right.
$29.5 million.
Okay.
And just this week or last week, we settled with CDK for $100 million. So the
Right.
gross settlement is $129.5 million.
You've got to have some happy clients this morning that benefit from that settlement, right? How many are we talking about, in fact?
Well, the numbers vary, but roughly 12,000 rooftops.
12,000.
There are 17,000 rooftops in the country, so roughly in that range. So, and it's not consistent. Some dealers did business with CDK or Reynolds back in 2013, 2014. So the scope, the range runs from 2013 through this month.
Okay.
So it's roughly a 10-year period.
Okay.
So dealers who've retired or sold, they're still part of the class. We call in this case the settlement class.
Okay.
So they can participate. So the participants will be dealers who did business through their DMS with CDK or Reynolds at any time during this 10-year window.
Right, right. Has this changed the way CDK or Reynolds does business? I mean, or are they just saying, hey, we're giving you the settlement. We're not, saying there's any wrongdoing. We're not admitting to that, and it's going to be business as usual. Because if that's the case, then what did they?
Yeah. So there's the monetary component of the settlement for sure.
Right.
When dealers ask me, what did we win?
Right.
Well, clearly we won. 100. When I say win, we settled. There was no adjudication.
Sure, but that's a win when it's especially that size.
And there was no admission of wrongdoing. It was our claims and their defenses.
Sure.
So having said that, what did dealers really recover? Certainly the monetary component, but CDK and Reynolds will say that the lawsuit, whether they attribute it to the lawsuit or not, I think they have come to the market in a friendlier way. I mean, over the 8 years, management has changed, and I think they have developed a friendlier relationship with dealers. So, is that a byproduct of the lawsuit? I would like to think so.
Sure.
So that's the non-monetary component. There has been more competition that's come into the marketplace because when parties that have monopoly control realize they're being called to the carpet, they tend to back off. And now you see that there are many other vendors that have entered the marketplace. So that I would put also in the category of a non-monetary benefit of this lawsuit. So it's not just the money; it's how the landscape has changed as a byproduct of.
But as a dealer, if I'm a dealer, would I expect to see those fees drop that started this lawsuit to begin with?
Yeah. Now, whether they drop as a direct result of the lawsuit is difficult to prove. I would suspect that they've dropped because the lawsuit allowed the marketplace to become more competitive, and competition has resulted in prices being more in line.
Okay.
So indirectly, I would argue that that is one of the benefits. It's not, we didn't incorporate it as part of the settlement. The settlement is strictly monetary.
Okay.
But an ancillary byproduct of the settlement, or the lawsuit, I should say, is that the marketplace is more competitive.
Sure. They probably spent millions of dollars on the lawsuit just in the last 7 years alone, right?
Well, no question.
Yeah.
I mean, they have very formidable law firms. They defended the case vigorously. Our attorney team has traveled all over the country for years, taking depositions, reviewing hundreds of thousands, if not millions of pages of documents.
Wow.
So this was a real labor task. There was no question that a large team of lawyers working collaboratively on both sides spent a lot of time and money litigating this case. So it's a good result when parties, generally speaking, can come to a compromise.
Were there any dealers out there that were CDK and Reynolds dealers that said, no, don't include me in the suit? I mean, it seems to me that if you are a Reynolds dealer out there and you're paying these fees and you've got all of your colleagues that are saying, hey, let's fight this thing, why would you not participate, right?
There is a right. Dealers have the rights to exclude themselves from the settlement. It hasn't been officially, judicially approved yet. We're going through that process right now. So there are opportunities for dealers who feel that, this settlement doesn't adequately represent their stake in this whole dilemma. So they certainly have the right to opt out, and they can exercise that right. And if they so choose, they can sue CDK or Reynolds on their own if they feel that it pencils out to do that.
Yeah.
By and large, I don't expect that to happen. I think dealers realize that it's better to turn the page, take the benefits of this settlement and move on. But certainly, once the case, there's probably 4 months left before the judge officially signs off on this settlement, so things could happen in between. And to your point, if dealers feel that this doesn't fairly represent their stake in this case, they can opt out and take private action against either one of these defendants.
Right,
or actually,
right.
CDK. The time to take action against Reynolds has passed because that case settled several years ago.
Sure. Len, this has been a tough year for CDK. I mean,
Well, yeah. I guess one could say, they wanted to take all their lumps at one time and have 2025 be a brighter year for them. I don't know if that was the reason they settled. I think it was more driven by the fact that the trial date is coming up in 3 weeks.
Right.
But they had a tough year. I'm sure they'll be happy to
now the headlines are
page.
Sure. Now the headlines are that the dealers are going to come back around and sue, or they are now, suing CDK because of the outage and what it costs them and the loss of business and such. Can you comment on any of that and where that?
Well, I
what's
can
your
say
take on that is?
Preliminarily, I'll say that this settlement has nothing to do with those claims. So dealers are not waiving their rights. Our case is entirely different. Those cases, those are not going to be slam dunk cases because they have to establish liability on the part of CDK. And I don't know that anyone knows yet exactly what transpired, whether there was negligence. I mean, essentially, it's a negligence case.
Okay.
So they'd have to prove that there was a duty that was breached by CDK. And I'm not an IT expert, but I would assume there are circumstances where even if you take extreme precautions from a security standpoint, that you can still get breached. So that remains to be seen. And
so that's
proving damages.
That's interesting that you say that. I'm not an attorney, but it's interesting that you say that. So the dealers would have to prove that there was negligence on behalf of CDK's actions that allowed this to happen. And if they couldn't prove that, then they wouldn't have a case. It would seem to me, obviously just the layperson, that I wouldn't have to prove that on their part. All I know is that CDK's company caused us to lose profits. But what you're saying is that in and of itself is not enough.
When dealers bring cases like that, they plead alternative theories. So negligence would be one theory. Breach of contract would be another theory, which I think is more in line with what you're saying.
Okay.
I paid for the service. I didn't get it.
Right.
But the other issue is that the DMS contracts provide limitations of damages. They provide for arbitration, at least the more recent vintage of contracts. There are caps on recovery. So it's not, even if they could establish either a breach of contract or negligence, the next step is, what are they entitled to recover?
Gotcha.
And I think that's why you haven't seen the floodgates opening with dealers suing CDK, because I think those that are spending the time to research whether it's a worthwhile endeavor to sue CDK are probably saying, well, I don't know that this pencils out.
Right.
Simply because of these limitations.
Sure.
So it's unlike my case, where I think there was universal discontent and a willingness to recover these funds because dealers felt that they were victimized. And you speak to a dealer, they don't look at it in legal terms. They say, look, this is my data. These are my customers. This is my payroll. These are my service repair orders. Why do I have to pay the aggregate? Why do I have to pay my DMS provider to get that information back? So that, I think, was at root.
Right.
And then when we discovered that the prices were being artificially increased, and we were able to coalesce together and create a class where dealers don't have to. That's one of the other benefits of a class action. It's not me versus my vendor. It's the universe of dealers across the country. So it kind of makes dealers a little bit more anonymous. And that's why I think, this class action mechanism will have a future in the automotive industry. Keep in mind, this is the largest class action settlement in the automotive industry insofar as it impacts all brands. So this is not like the Volkswagen case from years ago, during the emissions scandal where VW dealers filed a class action and it was just VW. This case was all brands.
Wow.
So this I think is a template. It's a model.
Yeah.
And a lot of people are asking me, well, what does this portend for the future? So turning the page from CDK and Reynolds, I think that dealers now have a clearer understanding that if they have a common enemy, for lack of a better term, they can, without having to put up hundreds of thousands, if not millions of dollars of their own money, they can get a team together that consists of fellow dealers that are similarly aggrieved,
right,
and fight this as a class.
Sure.
So I think it puts vendors, manufacturers on notice
I was
that
going to
dealers
say,
are educated now of what they can achieve without having to belly up, to the bar and hire a private attorney and spend an inordinate amount of money.
There is no question about it. This is a huge bell that you've rung here within the automotive industry. Huge win for dealers nationwide, as you said, all brands. And I think this will have this rippling effect because it's dealers that get together and go, hey, wait a minute, what's Ford doing and making us do this? And these other OEMs and all of the things that OEMs are pushing down on the dealer, including direct-to-consumer sales approaches and things like that we're dealing with in retail automotive. So there's a multitude of different things where a class action suit like this would be very effective, right? So dealers, I'm sure.
The phone is rung already since this settlement got out, and
Sure.
I've been studying other initiatives. I've been seeing the direction this case has been going now for a couple of years, and I knew it would have a good outcome for dealers. And I can tell you, I've been doing this 37 years, and I can get 10 calls a week from dealers who feel that they've been wronged and they want to pursue their rights until they find out what it's going to cost, and
Right.
they wind up taking it on the chin.
Yeah.
Because it just doesn't make sense for them to sue their manufacturer either financially or politically.
Right.
So, the class action mechanism resolves those problems.
Yeah.
Dealers don't have to come out of pocket.
Right.
They don't have to be standing out alone in a field as the enemy of their manufacturer.
Sure.
So this is a means by which the playing field can be leveled without dealers having to feel like they're waging war against the hand that feeds them, so to speak.
Sure. How many?
I think you're going to see this unfold over the next
Yeah.
couple of years in a big way.
How many parties have to participate in a class action suit in order to have it be defined as a class action suit? Could it be 5? Could it be 20? Is it 100? Is there a number?
Well, look, surprisingly, it only takes one. Really only need one.
For a class action?
For a class action.
Huh,
So we, in this case, we have 22 dealer clients of my firm historically that, signed up. So that even there, we find cover so that it doesn't look as though like one dealer is the instigator. So we'll even though we don't need 22, we'll get 22, and there are other legal reasons to want to do that.
Right.
However, by and large, the point I guess to be made is it doesn't take 100 dealers to get together. I used to bring cases like that. We called them mass actions. They weren't class actions. But I started this in the 90s when we got several hundred dealers together to sue Chrysler, Ford, GM, Nissan for retail warranty reimbursement. So that was kind of like the template for what we call a mass action, not a class action. A class action is much bigger and it's configured much differently. But I think that's going to be the wave of the future because getting 100 dealers together is very, very difficult.
Oh, yeah, no question.
Even if they all feel like, everyone wants the other guy to jump in the pool first. Here you don't have that problem.
So let me ask you, if I'm just for the viewer that's saying, well, let's say I've got 5 stores and they're all CDK stores. Am I already accounted for or protected, or did I need to actually participate in the suit?
By virtue of the class action being filed, they are, and procedurally there are some nuances. We call it a putative class action, but every dealer who's a CDK or Reynolds customer when we filed this case was part of the putative class, so they didn't need to do anything. Now that we're at the stage where the court is going to certify a settlement class, every dealer is involved. They still have to take action to recover them. And it's a little premature. There's going to be a claim form that needs to be filed, and we'll be sending there'll be advertisements in the automotive news. Part of the process is getting the word out to all of the impacted dealers. So there'll be emails, hard copy letters, half-page ads in automotive news.
CBT news announcement.
I think we contacted your office already to publicize this, digitally and so forth. So every dealer that potentially could collect money under this settlement will be notified. We'll have website. We have a separate dedicated website just for this settlement that will contain all the forms and details. And that's another point I think it's worth mentioning. A lot of companies come out of the closet. We call them claims settlement companies. They see a settlement and they seek to capitalize on it by saying to a dealer, hey, are you aware about the CDK settlement? You should sign up with us and we'll help you recover money.
Oh, wow.
It's not illegal. it's a legitimate business,
Yeah.
but there's no reason that a dealer should incur that expense, because typically those companies, those settlement claims processing companies, charge a percentage.
Gotcha.
So there's no reason for that. They can just call my office or Milberg's office, or go onto the website and have it done for free. So giving away 20 or 30% of your settlement is not necessary. But dealers will start getting those letters and probably create a lot of confusion, which is why we're going to continue to keep in touch with dealers so they understand their rights. And
no,
we'll help
absolutely.
them.
We'd love to have you on more to just provide updates on this, because I know there's going to be a lot of questions that dealers will have, and that obviously at the forefront of how do I collect, or what's the next step. I would imagine involved in those forms would be the agreement by that particular dealer to say, this is a final deal. I'm not going to come after you for the same thing if in the event I accept this check as part of the settlement, right?
That's right. If they participate in the claim process, and if they don't opt out, then they are bound by this settlement, and they'll be effectively releasing CDK from any further liability. So this would be their chance. And, I'm sure your listeners are saying, well, how much is in it for me? What does this settlement really mean? It sounds great. $130 million.
Right.
Well, the answer is I don't know yet. However, the reason for that is it all depends on how many dealers file claims. So the pie, will be split up amongst potentially 12,000 rooftops, unless only 9,000 file claims, in which case the pot changes per dealership.
So what I would imagine then, there's got to be a cutoff that says, okay, you had until such and such a day, and now we've got to disperse the funds. You missed your deadline. Another reason they need to stay tuned to all of the media out there to say, okay, what's going on here, and what, so I don't miss that deadline, right?
Yeah, we're waiting for the court to establish that deadline. It'll probably be sometime in the end of this year or the very beginning of next year.
Right.
So there's plenty of time, and that's the whole point of waiting 4 or 5 months to finalize the settlement, so everybody who wants to participate can get their claims forms in. But yeah, it's this will be an ongoing educational process to get dealers to weigh in.
If I'm a dealer and I'm contemplating or I'm suing CDK because of the outage or what have you, does that, when I sign that release for this lawsuit, does it negate me from being able to sue them on other issues? It's only on this issue.
Yeah, the court is very aware of the other potential claim and has carved out an exception to make sure that dealers are not unwittingly waiving any rights they might have for any damages related to the outage or any other dispute that they might have with CDK. So this is a very finely tuned settlement.
Right.
So dealers would not be unintentionally waiving their rights to any other claims.
Right. And I would imagine this is like a one lump sum deal where they're not paying these dealers over time or anything. There's not terms on this, right?
No. There'll be a day, probably the beginning of next year, if they file the claim process, that they'll be getting a check from us in the mail in one lump sum.
Right.
It's complicated as it was. The settlement component of it is relatively straightforward.
Yeah. Gotcha. Well, Len Bellavia, founding partner of the Bellavia Blatt law firm, also known as Dealer Law, doing great work for dealers all over the country. I think on behalf of all the dealers, I can say thank you. A big win for the franchise dealer that's out there that it always gets pounded on from either vendors or OEM requirements or what have you. So we've seen it all. So I want to say this is a big win for the little guy, but I don't know how little automobile dealers are, but nevertheless, I'm sure they'll take it and be happy with it. And so great job. Congratulations to you and your entire team. And as I said, love to have you back to do, really kind of constant follow-ups on this, because there's going to be a tremendous amount of questions. I know I'll probably I'll get them in my email as well that say, hey, when Len's on, ask him about this. So.
That's fine. Jim, as you well know, because your history is, you probably grew up about 5 miles from where I grew up, and we both were in the car business. And people say, why do you take these oddball cases that take 8 years for you to see a dime? I think it's because I sold cars. I was a lot boy. I kind of, the big development when I was young and working in my family showroom was the advent of the fax machine. So I've seen it all. So when I see dealers get victimized, I might take cases that other lawyers that would look at this and say, who wants to wait 8 years to get a payday? I'll do it because I have those memories of what it's like to make a living in the auto industry as a dealer. So I kind of relate a little bit more maybe than somebody else might.
Yeah. you're the car guy attorney that we need in the corner, right? When things like this come up, because often, as you know, many attorneys, and I know when I've gone in to speak to some of them, is they'll put their consumer hat on. And right away, they take the side of the consumer out there that says, well, car dealers aren't fair in this. So it's great to have somebody that actually was in the industry. I'm sure there's others out there, but certainly you're leading this, and to have that car person, that car guy, in our corner that understands all of this is great. Really is.
Well, I have a little advantage. My family is still in the auto industry.
Okay.
And I'll go in the showroom sometimes and just gather some intel. I think I kind of missed the showroom floor action. So on a weekend, I'll go visit and figure out what the next case might be based on what I hear from all the salespeople. So it never leaves your blood.
No, it never leaves your blood. I like in my position here at CBT News, where I'm kind of like that retired ball player for NFL, where they put them on Fox Sports or ESPN, and I get to still be in the auto industry, although I haven't run a dealership in quite some time. But it still allows me to be in touch with it. So
that's right. You and I are aligned on that for sure.
That's right. Well, thanks so much, Len Bellavia, again, founding partner, Bellavia Blatt law firm, doing great work for dealers all over the country. Really appreciate all the time you've given us.
My pleasure, Jim. Thank you again.
Thanks.
Thanks for watching Inside Automotive with Jim Fitzpatrick.